Greetings, this is Trent Goodbody, Freedom from Government here, and today I have some very important information about obtaining relief for deprivation of rights under color of law. Do you feel like you have been done dirty by agents acting under color of state law? How do we get remedy when they violate our rights? The one thing that has been proven to work time and time again is the federal Title 42 U.S.C. 1983 claim. Stay with me as we explore this very effective remedy in today's video. Isn't freedom nice? Well, that was rude. Anyway, Section 1983 of Title 42 of the United States Code provides, in part, civil action for deprivation of rights. Every person who, under color of any statute, ordinance, regulation, custom, or usage of any state or territory or the District of Columbia subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws shall be liable to the party injured in an action at law, suit in equity, or other proper proceeding for redress. Under this federal statute, a person who is deprived of their rights under the Constitution by someone acting under color of law, either federal, state, or local, can bring a federal cause of action for damages and other relief. The statute provides a right of redress for parties deprived of constitutional rights, privileges, and immunities by an official's abuse of his or her governmental position. So what do you need? Elements of a cause of action. Generally speaking, there are three elements required to bring an action under 42 U.S.C. 1983. The plaintiff must prove the following. Number one, he or she was deprived of a specific right, privilege, or immunity secured by the Constitution or laws of the United States. 2. The alleged deprivation was committed under color of state law. And 3. The deprivation was the proximate cause of injuries suffered by the plaintiff. There must be a causal connection between the defendant's action and the alleged injury. This means that harm experienced by the plaintiff must be the result of an action on the part of the governmental entity or its agent. So who can be sued? Anyone acting under color of law can be sued under the statute. Local governments, municipal corporations, and school boards can all be subject to liability under 42 U.S.C. 1983, but only if their policies or procedures were the proximate cause of the constitutional deprivation and the injury alleged. Generally, in the absence of a policy claim, individuals employed by federal, state, or local government are the parties named as defendants. They are sued individually for actions they took in their official capacity. In some cases, private citizens can become liable in a 1983 action if they acted in concert with public officials to deprive someone of their constitutional rights. Tow companies, for example. On to the issue of qualified immunity. An affirmative defense of qualified immunity is available to defendants who acted under circumstances where a reasonable official may not have understood that the conduct alleged was illegal. It is not necessarily to show that the defendant officer was acting in bad faith, and indeed the officer's subjective intentions, such as a good faith belief that what he was doing was lawful, are irrelevant. To defeat qualified immunity, it is necessary for the plaintiff to show that, given the facts and circumstances alleged, any reasonable officer would have known that the conduct complained of violated well-established law at the time of the incident. And damages. A victim may recover compensatory damages, injunctive relief, and, except in the case of municipal defendants, punitive damages. The prevailing plaintiff can also recover the costs of litigation and reasonable attorney fees. This means you can get paid. and they can make the state court case go away, injunctive relief. Also, some people say that you have to claim to be a U.S. citizen to file a claim under the statute, but this is simply not true. You can be a state citizen or foreign national. It just has to occur in the jurisdiction of the agent that violated your rights. Personally, I would choose to act as the living man, using a person or commercial entity to bring the claim. That way they cannot force you into the role of U.S. person, because you are instead a man using a person. Also, to say that you have to be a U.S. citizen to bring a claim under Title 42, 1983 is hogwash, because it doesn't matter who you are. It matters who they are, more specifically, an agent acting under color of state law. Even people visiting from foreign countries can bring a claim under Title 42 because they are not the one whom swore an oath to uphold your rights. They are. So why not file a complaint? So you can ignore that inadequate court order that has you shaking like a dog, crapping razor blades about the possibility of being thrown in jail for seeking redress. Just include a request for injunction against that BS constitutional overreach in your complaint. And remember, you only have 2 years to file before the statute of limitations bars you from relief. This might sound like a long time, but it really flies by, believe me. And if you need to get on the fast track to learn how to litigate one of these suits properly, contact me on Facebook or stay tuned as I walk everyone through my own suit here on this channel and on my website, freedomfromgovernment.org, where you can find a wealth of information on the subject. And don't forget to also visit shop.freedomfromgovernment.org, where you can find all the tools you need to make that case, including notice stickers, exercise your rights cards, dash cams, books, and more. And please, if you appreciate and enjoy my work, don't forget to like and subscribe. Peace.